Call the second case on this morning's docket. Case number 113828, State of Kansas v. Anthony S. Smith.
Mr. Chief Justice, may it please the court, counsel, Angela Davidson, appearing for the appellant, Mr. Anthony Smith. Mr. Chief Justice, may I please reserve 3 minutes for rebuttal?
3 minutes is granted.
On January 7th, 1985, Mr. Anthony Smith pled guilty to 1 count of burglary and 1 count of theft in Sedgwick County case 84 CR 1626. On March 29th, 1985, he was sentenced to 1 to 10 years and 1 to 5 years concurrently and placed on probation. The court ordered Mr. Smith to reside at the Sedgwick County Community Correction Residential Facility. Mr. Smith remained at the residential facility from March 29th, 1985 until March 6th, 1986. He returned to the facility on July 25th, 1986, and remained there until October 21st, 1986. On October 29th, his probation was revoked and he was ordered to serve his underlying sentence with 161 days of jail credit granted beginning May 21, 1986. At the time, Mr. Smith was also resolving case number 1985 CR 133. His probation in that case was also revoked on October 29th, 1986, and he was ordered to serve his underlying sentence with a start date of September 24th, 1986. Mr. Smith filed a pro se motion to correct an illegal sentence on August 24th of 2014. Mr. Smith claimed he was entitled to 14 months and 2 days of jail credit for the time he spent at the residential facility. We are here before the court today due to the district court summarily denying Mr. Smith's motion for jail credit based on the motion for correction of an illegal sentence. The Court of Appeals, in reliance on State v. Muldrow, held that the defendant's deadline for appealing the award of jail credit starts to run from the date the district court first awards jail credit, and it upheld the district court's decision in this case applying Muldrow. Muldrow is one of several cases addressing whether the district court has jurisdiction to correct an award of jail time credit post-sentencing, which is how we end up before this court today. The most prominent cases, the most common cases that were addressed by both parties in this case and that were cited by the Court of Appeals in this decision are the cases that the appellant would like to bring to the court's attention today and is asking the court to consider and asking the court to rule upon, so that there is a consistency in the cases, which presently there is not. It's Mr. Smith's position that the leading case, which came from this court in 2005, which is State v. Guzman, is the case that should be followed. In that case, this court reached a decision on the merits of a nunc-pro-tunc motion to award jail time credit that was filed 2 years after sentencing.
Can we back up here just?
Yes, Your Honor.
Yeah, in terms of the request, you said it's for time spent in the residential facility while he was that as a result of a sanction imposed, or was that while he was waiting? How did the time spent at the residential facility come into being?
Your Honor, the record in this case is confusing.
Yeah, that's what I thought.
It's extremely confusing. But as far as I can tell from reviewing the record, I think that is simply what the court ordered, what the district court ordered for whatever reason.
But
it was a condition of his probation, I believe.
Was there ever a determination made at the time, or when he was subsequently sentenced, that would be given credit for time served on that case, or was it?
There's no indication in the record that the district court. The only indication.
I mean, typically when a sentence is imposed, there's always this portion of that sentence that talks about credit for time served, almost always. Did that ever take place?
What's in the record that indicates that, Your Honor, is there is a district court order that indicates that his jail credit would begin, that his sentence would begin as of May 21st, 1986.
I mean, you either get it or you don't get it. You either have jail time credit or you don't.
Well, in the sentence
It's
begin
not
date,
discretionary. You either have it or you don't.
That's correct, Your Honor.
the sentence begin date of May 21st was essentially 161 days of credit.
That's correct.
And why doesn't that end this case? That was an order of October 29th, 1986, which was after the residential treatment time. Isn't that correct?
That's correct.
So the judge made an order. Usually, if the judge makes an erroneous order, that has to be appealed. How do we get around that here, under the facts of this case?
I think you get around that, Your Honor, because, and that's our position, is that based on the Guzman case, if you look at that as a nunc-pro-tunc order can be appealed at, if this is a motion for a nunc-pro-tunc, he can appeal that at any time.
And so let me just make sure then the order you're asking us to correct is the October 26th order?
Correct.
Okay.
There's clearly case law that indicates that he can have credit for being in a residential facility. I don't think that's being disputed, that a defendant can have jail time credit for time spent in a residential facility. The case law is clear about that.
What's before us to say that wasn't considered? That this 161 days doesn't account for the time in the residential facility?
I think the 161 days does account for the time in the residential facility, Your Honor. I think the issue is, make sure I'm understanding your question, I'm sorry. I think
what's the clerical error that you rely on?
The clerical error, Your Honor, is Mr. Smith is saying that he's not getting that time. That time has not actually been applied to his case.
Even though there was a credit of 161 days.
Correct. That has not actually been applied in the journal entries.
And that's not the 14 months.
Correct.
It's only a part of it.
Right.
But part of our problem here is that all this happened at an October 29th, 1986 PV hearing.
Correct.
And we don't have a transcript of that hearing.
Correct.
So we don't know if this was fully litigated and decided. And if it was, that's not a nunc-pro-tunc, that's an appeal, isn't it?
If it was fully litigated and decided, then there is an issue about whether he should have filed that within 10 to 14 days from that decision. I think that's an issue before this court, yes.
We don't nunc-pro-tunc a district court's erroneous ruling, do we?
Correct.
Okay, that's my question.
I would concede that, yes,
And
Your Honor. However,
do you have an obligation to provide us that record so that we can make the determination of whether this is a not even conceivably a nunc pro tunc situation versus a litigated, disputed issue that was resolved against your client.
I think if the record is in existence, yes. I think there is no indication whether, if the record was not properly made, then there is no way that a pro se defendant can provide that. There's no case law that I have found that puts a burden on a pro se defendant to provide that if there simply is no record.
Are you telling us there is no record of the 86 hearing?
I do not know, Your Honor, if there is a record of that
Does it-
86
Do you know
hearing.
whether it's been sought?
I have not been able to locate it, Your Honor.
Okay.
I can tell you, however, I did not do the brief. I came into this case after that fact. I have tried to locate it and not been able to locate it.
Okay.
I think even if it is not a nunc pro tunc, assuming that there was a hearing and it should have been appealed at that time, the argument could be made, and was made, that he could have sought relief under a 1507, which he can also raise, that this sentence violates the Constitution. It's obviously ordered in excess of the maximum sentence authorized by law. If the court did give him credit for that time, and then that time was not allotted to him, then his sentence does violate the excess that was authorized. There's also a due process violation because he's being incarcerated longer than his lawful sentence required. Again, the Court of Appeals rejected that argument, simply finding that he did not make a manifest injustice argument to support his 1507 argument, which we would have to concede that was not done.
So we have to determine this is a nunc pro tunc situation in order to give your client relief.
Yes, I think that is the issue before this court, is whether this is a nunc pro tunc situation when a jail time credit is raised post sentencing and not raised within at this time it would have been 10 days for the appeal. If it was raised currently, it would have been the 14 days that a defendant has to file an appeal. There are several cases, two of which, there's the Guzman case that comes from this court that allows that to be done. There's the Mitchell case that comes from the Court of Appeals that has allowed a nunc pro tunc motion to correct jail time credit filed post appeal time. Then there are the Olson case, the Muldrow case, and the Blazer case from the Court of Appeals that have rejected a defendant's ability to use a nunc pro tunc motion, arguing that the district court does not have jurisdiction.
In this case, as a practical matter, what would the correction be, the specific correction?
The specific correction would be to allow him to actually allot him
No,
that
I want
100.
to know what would be done to the journal entry.
It would be to give him that 161 days from that October 29th journal entry.
And so it would change the sentence begins date on that journal entry?
Yes.
How do we know that that time wasn't allotted to the other case, that he was also on probation?
We do not.
So in fact, this may not make any difference. If he did receive credit in a different case, he's not entitled to it in both cases.
That's
Isn't that
correct. And we cannot tell from the record in this case if it was allotted to the 1985 CR.
Well, I'm gonna go back to the
133 case.
broken record. If we have to have an evidentiary hearing to determine what's correct, how can it be a non-pro-tunc? A non-pro-tunc is make it what it should be. If we don't know what it should be without having an evidentiary hearing, then I don't understand how that's a ministerial act.
Because our position would be you can have an evidentiary hearing to determine, the only purpose of the evidentiary hearing would be to ensure that there's no credit due in 85 CR 133. If there's no credit due in 85 CR 133, then it would still be a non-pro-tunc order to correct the journal entry in this case. Because there would be no other order in which it could be. I believe I'm out of time, Your Honor, unless the court has further questions.
Do we have any more questions? Thank you, counsel.
Thank you.
May it please the court, counsel. Good morning. Again, my name is Lance Gillette, an assistant district attorney on behalf of the state of Kansas. I'm going to start off with my first point being where this court ended its questioning of opposing counsel. I heard opposing counsel concede that this has to be a non-pro-tunc situation if they're able to try to seek any kind of fix or any kind of additional credit. The problem is here, the record, as the court described, is at best broken. I believe the Court of Appeals described it as sketchy, and I think that the state did its best below to demonstrate that this defendant in particular was held on at least 2 cases during the approximate time frame he's seeking additional credit for. We don't have any information as to which case he was put into a residential facility. We can't, other than his bald claim, say that he was actually in a residential facility. And so I think that based on that alone, this court should uphold the ruling of the Court of Appeals. The record here is broken. It was the defendant's duty to demonstrate a record affirmatively showing error, and he's failed to fulfill that duty.
Step
Can I
back.
talk about, excuse me,
Go ahead.
can I talk about whether it's an illegal sentence? I know we have a concession on the other side, but we can't concede to a question of law.
Right.
And it seems to me that jail time credit is mandated by statute, is it not? It's 2166-15 now, formerly 2146-14, mandates jail time credit.
Correct.
And we've said that an illegal sentence is one that does not conform either in duration or character to statutory requirement. And if jail time credit is statutorily required, then why isn't the failure to include that credit in the sentence a failure to conform to the statutory provisions with regard to the term of sentence? Do you understand where I'm going with that?
I do, and unfortunately I think that there are a lot of layers to that onion that the court has proposed. And part of that is because of the language that we've seen over the years when issues like this have occasionally come up. And yes, 2146-14 that applied then, 2166-15 that apply now, impose a duty on the district court to calculate jail credit. What they don't do, and what the rest of the sentencing statutes don't do, is provide that jail credit is actually part of a sentence. That is simply a time calculation that is used by the Department of Corrections to establish a sentence begins date. And it's relevant for good time. So the district court is still imposing the sentence, and the state would grant today that yes, the district court has a duty to conduct a jail credit calculation at the time of sentencing. I don't concede that it is actually part of a sentence. And part of that stems again from this court's opinion in Lofton, where this court found that the illegal sentence statute 3504 subsection 1 does not work to get a jail credit. A jail credit calculation is not part of an illegal sentence. It does not found an illegal sentence claim.
What's the mechanism then that Mr. Smith and others who, let's just say, for argument's sake, that he didn't get his jail time credit, that he was entitled to 161 days, and the court didn't give it to him or didn't recognize it in the record, it's not reflected in the journal entry. How does he get relief right now? What's the mechanism? You can't, the Court of Appeal says he waived it. You can't waive something that has already been determined that you're entitled to. It's really more a matter of math. You've served this much time, pre-sentence, incarcerated, you're entitled for credit. And let's say you don't get it, and that's basically what what's the mechanism then?
Again, there are a lot of layers to that question because of the structure here, but assuming.
Yeah, I'm just saying assume.
Okay.
He did not get it, that he was entitled to it in 85 CR 133, and the court did not give him his 161 days, which is what he's saying. Let's assume that happened.
Sure.
What does he do? He didn't waive it. He can't be out of luck. He's entitled to that time. How do we get there?
Well,
how does he get there?
He can waive a lot of things by not appealing, and that's how he needed to get there. That's my first response, is that it was to appeal. Now, if he were to try to seek
What if he didn't
resolution
discover
today,
it? What if he didn't discover it until later? I mean, you're saying, yeah, it's not a part of the sentence.
Yeah.
This is something that's an administrative function of the Department of Corrections that starts the sentence begins date, and really the sentence ends date too, because that affects the length of the sentence.
all right.
And
If I start stacking those presumptions to create a perfect scenario, then I think that the best mechanism for a defendant in that situation would be to file either a 60-1507 or a 60-1501. And he can do that by making claims that his sentence was unconstitutional. He could fault his attorney at the district court level for not coming to him and going over this jail credit calculation. And I got a little confused in hearing the argument today that if this is just a question of KDOC time, then the remedy there is a 1501, and he needs to challenge that calculation.
that was your argument. That's basically what you're saying. This isn't a part of a sentence.
That's part of what, yes.
That's what you're saying.
That is part of what I'm saying as well, that he can go after it that way. And in those instances, he would need to demonstrate manifest injustice, and he didn't even claim it here. So we can't construe his motion as a motion to correct, or as a 1507 based on what he was presented. Nor, for what it's worth, did the defendant in his original motion even claim his sentence was illegal. He just made a bald claim saying he was held in these times, he wants credit.
So that gets to the question I was about to ask,
Sure.
which is the defendant is characterizing the filing as a motion to correct a legal sentence. Do you concede that what is before us is a motion to correct an illegal sentence?
It sounded like today that the defendant is actually claiming that this is a motion for a non-pro-tunc.
Well, that's one of the subcategories of illegal sentences, a clerical error, right?
That would fall under subsection 2 of a clerical error, and I think that the Mitchell opinion spoke to that a little bit.
I guess where I'm going is, if this really is a motion to correct an illegal sentence, filed under either of the subsections of 3504, is it really a question of jurisdiction, or is it just a question of, on the merits, can the defendant demonstrate an illegal sentence? In other words, your argument is, look, jail credit is not part of a sentence.
Right.
Is that a jurisdictional argument?
I think it can be, and that's what res judicata and the other case law that's coming. That comes
But how is
into
it
play
a
here.
jurisdictional argument? That's my question.
That essentially, effectively, defendant has waived jurisdiction because of the fact that he did not appeal. And
But the motion before the court, if we've established, is a motion to correct an illegal sentence, and the court has jurisdiction to decide that motion. Why isn't it just a decision on the merits?
I mean, if it were a motion to correct an illegal sentence, then I suppose that it could be.
Before you decide the jurisdictional question, don't you have to know what kind of a motion you're considering?
It would certainly help. And
Well, isn't it necessary? How in the world can you decide whether you have jurisdiction unless you know what it is that you're being asked to decide?
by looking at the motion, and here it was just asking for jail credit. And
Okay,
the
but that
question-
gets back to this is the confusion, because it's just a motion for jail credit and everyone treats it like it's a motion to correct an illegal sentence.
It was treated as a motion for jail credit at the district court. It was rejected on jurisdictional grounds.
Okay.
Now, the defendant, of course, would love to treat this as a motion to correct a legal sentence because it gets him around all of the time bars. The problem I have with the Mitchell opinion, if I could speak to that briefly, the Court of Appeals, with all due respect, shoehorned the claim in Mitchell into subsection 2 by calling this a clerical error. And I think that that's disingenuous. And I think that some of the court's questions here today have illustrated that point. There are at least two aspects of this that make 3504 subsection 2 an invalid mechanism as well. Number one, this defendant, as are many others, can be held on multiple cases at the same time. He's not entitled to duplicate credit. That is a question of fact that has to be decided by the district court. It is not a clerical function of a district court clerk or even the state in preparing a journal entry. Number two, and I think that this was illustrated was illustrated in this court's case, Denny, 278 Can 643. There's a question of what was that confinement? What was that pretrial confinement or that pre-sentencing confinement? And would it suffice to be classified as the type of confinement that would merit jail credit? Obviously, a time in a residential facility could be one or the other. If it was at his request or as a condition of bond, Denny says he's not entitled to it. So that's yet another factual layer, a factual question that again makes 3504 subsection 2 inapplicable. This isn't simply a clerical function. If I could speak to Guzman as well very briefly, I don't think that Guzman can be construed to say that this court reached the merits of the claim. My reading of Guzman, which I think is pretty clear, is that in that case, the district court rejected the motion on its merits. There was also no jurisdictional argument made, so Lofton was not addressed. What this court did is instead of reaching the merits, it addressed 2146.14 to determine whether being on house arrest would qualify for jail credit, and they found that it would not. So again, it gets a little circular, but again, it addressed the simple question of whether or not a type of confinement would suit and meet the requirements for jail credit, and found that it was not. So it wasn't reaching the merits wasn't reaching the merits of a claim for jail credit. It interpreted 4614 to flatly say, look, house arrest doesn't count. The state believes that the district court did not err here in citing to Muldrow, and I think that the cases are also cited by opposing counsel Blazer and Olson to highlight the fact that the real remedy here is for a defendant to appeal within 14 days. For this defendant, it would have been 10, based on when he committed his crime and when he was sentenced. I would also note that the dissent in Mitchell also points that out.
And that's 10 days from pronouncement of the sentence.
10 days from the pronouncement of sentence.
And if the journal entry isn't filed within that 10 days or isn't provided to the defendant, just out of luck, because that's very often what we're talking about, is the credit didn't get into the journal entry, didn't get to the DOC, didn't get affected, right?
Then I think that then even as a prophylactic measure, file an appeal. If you don't have it done, if it's not done in time, file your notice of appeal saying I haven't received my credit. I don't know what my sentence is.
Well, why wouldn't that be a clerical mistake? If you have maybe I'm misunderstanding, but it sounds like you just, in your back and forth with Justice Johnson, you said if there had been a pronouncement of the sentence that says X, and then 10 days elapse, and then the journal entry is filed that says Y. Why isn't that deviation between the pronouncement and the journal entry a clerical error?
I'm trying to think if that scenario would fall.
And isn't that essentially boiled down what the defendant in this case is saying?
I don't think that that's what the defendant in this case is saying. Again, I don't. That specific scenario, maybe there would be some sort of a clerical error there.
Let's just
wait.
make it real obvious that the defendant gets sentenced to 36 months at
Okay.
pronouncement, and the journal entry comes out and it says 360 months.
Well, that's a different question though as well, because what you're talking about there is the actual sentence that's pronounced. So that would definitely be a clerical error. When we're talking about
Well,
here in jail credit,
The subsection 2 isn't limited to just sentences. It's clerical mistakes in any judgment order or any other part of the record.
right?
So it's broader than just a sentence. You would concede that.
It
right?
is, but again, it's I guess a different hypothetical, more suitable. Maybe what you're asking is if the district court says on day 1 jail credit of 36 days, and on day 2 when the journal entry comes out it says 24 days.
Right.
Maybe that could be a non-pro-tunc, but that would simply resolve itself, I think, as well. I don't know that. I don't think that that's what the defendant was really claiming here, and I think that is an issue that can be waived over time as the case law has indicated.
Well, how can
And
it be
is
waived
that-
when the
Go ahead.
how can it be waived when the statute says it can be corrected at any time?
Because it's separate and apart. It's not a part of the sentence. It's something that has to be done at sentencing. They're not necessarily the same thing.
And in the state's view, is that hypothetical you've just talked about where the judge says 36 days and instead it's 360, is that a different situation than when I think it's probably a fairly typical practice of the judge saying, and the defendant will be entitled to jail credit, period, no more specificity. And then in the journal entry, somebody calculates that and puts in a number.
Right.
Is that a different situation?
To speak to that situation, I think that the statute is pretty clear that the district courts should be calculating the jail credit and pronouncing it, or at least giving some indication of what it is. That I don't know that saying you're entitled to whatever you're entitled to is sufficient. I don't.
And at that level, whose burden is it to come forward? Is it the defendant's burden to come forward and say, I should be entitled to X days of jail credit? Or is that the state's burden?
If there's a dispute at some point, it would be his burden to come forward. If there's a dispute with what is eventually journalized, and again, he could acquiesce to what's shown. Under this hypothetical, the district court says you're entitled to whatever you're entitled to. State later fills it in on the journal entry. If the defendant has an issue, then the burden would be on him. But again, I don't think that that's necessarily I don't think that's a clerical issue. That's something that's factual.
Is the defendant waive the issue if he doesn't present evidence at the time of sentencing as to what the jail credit should be?
The statute does not speak to placing a burden on the defendant. It's the burden is on the district court. I think when he waives is when he fails to appeal within the statutorily authorized time frame for an appeal. And that is at that point in time is when I feel that he waives.
Would the same rules apply to the state if the district court had gone long on the jail time credit in a manner that the state felt was inappropriate, that the state would have an obligation to timely object, and if it didn't object, it would waive the fact that the defendant's going to get out of jail sooner than the state would have thought was proper?
My answer to that would be yes, and I think it was Guzman was the case. The state actually was the one that filed a motion seeking to change the jail credit, because the district court. Let's see. It may not have been Guzman, but one of this court's cases, it was the state that challenged a defendant's jail credit calculation because he had been held in Kentucky, and the district court treated was treated a jail credit question as a motion to modify, and the state appealed that. And this court said, no, state, you are stuck with what the district court did. It was a question reserved in that case. So again, a little bit different factual scenario, but the same rules should apply. If I may have just 30 seconds to wrap up, Your Honor.
30 seconds is agreed.
Thank you. So the state would ask that this court uphold the ruling of the district court and the Court of Appeals. Again, we don't think that the record here is sufficient to merit relief or further consideration, nor do we believe that the precedent supports the defendant's claim in this case. And we believe he's waived his jail credit calculation.
Any more questions? Thank you, counsel.
Your Honor, I want to start with the court's question regarding who has the burden to establish the jail time credit at the district court. And as a practical matter, the defendant rarely, if ever, has access to that information. And as was indicated in many of the cases cited in the briefs and by the Court of Appeals in its opinion, and just throughout the cases addressing these issues, what is typically in the journal entries regarding jail credit is an order that the defendant will be given jail credit as earned or something to that effect. There's even a case, and I apologize, I can't pull up the name of the case right now, but that indicates that that is sufficient for the district court to use that language, simply that it doesn't have to make a specific ruling as to jail credit at the time of sentencing, but can simply indicate that jail credit as earned is sufficient.
Counsel, acknowledging that point, it's unquestionably the defendant's burden to demonstrate error in this
Correct.
proceeding. And I just can't figure out how you get around all your record deficiencies. I understand this was a long time ago, and I understand you're a latecomer to the case, but help me out on that.
Well, Your Honor, I think even given that fact, the case law from this court is clear that the record is clear that he was, along the way, given credit for 161 days. And that there is not a journal entry that gives him credit for that time. And that when you sit down with the cases from this court and the Court of Appeals, he is entitled to that time. And whether he raises it with, whether he files an appeal within his 14 days or his 10 days or not, whether you look at it as a nunc-pro-tunc or a motion to correct an illegal sentence, one way or another, he is entitled to that time. As the justice indicated, you can't simply just deny him the right to the time he served. And I think even as sketchy as the record is, you can tell that he served that time. And I think as confusing as the case law is, it's clear that it's a due process violation not to give him his credit for that time.
I understood you earlier to concede that we do not know which case that jail credit was awarded in.
No.
And if we don't know that, then we don't know whether or not he received the credit in this case.
I miscommunicated that, if that's what I indicated. There are two cases that he was in custody on during this time period, and then there's, I believe, 3 other cases that came after the fact. And it is unclear, but I think you can tell that he was in custody.
Well, you had an exchange earlier with Justice Lukert, I think, in which the question was, the defendant's not entitled to jail credit time in multiple cases.
Correct.
And so how do we know whether or not he received that credit in a different case?
The second case he was dealing with at the same time.
Right, the 85 CR 133, I believe. And it is hard to tell. I will concede
I thought you
that.
said you can't tell.
It is hard to tell.
I don't know where I got this, but my notes indicate that there was a June 24th, 1985 PV hearing and that resulted in a sentence begins date of March 4th, 86, and then the next PV hearing, which was, I think, the October 29th, and there was sentence begins date of 5/21/86. So I was confused. We had two hearings and two sentence begins date. So back to what they're asking is how do we know what went where?
Because both cases were the second hearing, right? Second PV hearing?
Yes, I believe so. Yes.
And that's the one where you're saying he got the jail credit.
Yes. And I think if this court remands it to the district court, that can be resolved. His records are there. The district court can resolve which of those two cases, if either, he served that time on.
Have any further presentation?
I do not, Your Honor.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement. This time.